Good morning, everyone. Welcome to our press conference on the systemic review on police strip searches. Just a few housekeeping notes. There will be time for questions following Mr. McNeilly's statement. The press conference is being live streamed on our YouTube channel. The press releases will be available following the conference. Before I introduce Gerry, I just want to thank Rosemary Parker and staff in our agency whose work on the report was invaluable. I also want to thank counsel on this report, Mark Sandler, as well as Ben Elzingating. Mark is right there, and Ben. And with that, I give you the Independent Police Review Director, Gerry McNeilly.
Well, good morning, and thank you very much for those of you who are here today. This is the release of our systemic strip search review report. My name is Gerry McNeilly. I'm the Independent Police Review Director for Ontario. Each year, well over 22,000 strip searches are conducted by police officers in Ontario. The majority of those strip searches are carried out by Toronto Police Service. In many circumstances, there will be a valid law enforcement justification for conducting a strip search on someone who has been arrested. However, because the level of intrusiveness and the impact strip searches can have on individuals, police services and their officers must clearly understand when strip searches are appropriate and how they are to be conducted. Police officers must also conduct or authorize strip searches in compliance with the law, including Section 8 of the Canadian Charter of Rights and Freedoms and the Supreme Court of Canada decision in Regina versus Golden. The Canadian Charter of Rights and Freedoms states, everyone has the right to be secured against unreasonable search and seizure. In the case R versus Golden, which is the landmark decision on the constitutionality of strip searches in Canada, in that decision in 2001, the Supreme Court of Canada defined what amounts to a strip search and when and how it can lawfully be done. This case came out of an incident in 1997 where Metropolitan Toronto police officers arrested Mr. Ian Golden. They arrested him inside a restaurant for trafficking of cocaine. Officers conducted intrusive strip searches and forcibly removed a package of crack cocaine from Mr. Golden's buttocks. Mr. Golden appealed his drug trafficking conviction to the Supreme Court of Canada on the grounds that the strip search constituted an unreasonable search and seizure, contrary to Section 8 of the Charter. The Supreme Court of Canada overturned the conviction and acquitted Mr. Golden of his charges. In its decision, the Supreme Court of Canada said, a strip search is a more intrusive search, and accordingly a higher degree of justification is required in order to support the higher degree of interference with individual freedom and dignity. In order to meet the constitutional standard of reasonableness that will justify a strip search, the police must establish that they have reasonable and probable grounds for conducting such a strip search, and that the strip search is necessary in the particular circumstances of the arrest. It is extremely concerning that almost two decades after the Golden decision, police continue to conduct strip searches in violation of the law. This comes at a high cost to those directly affected by an intrusive search and to the justice system, especially where an unlawful search results in the exclusion of evidence or the staying of charges. In one court case from last year, police arrested a woman for drinking and driving. Shortly after the arrest, officers found a small amount of marijuana in her purse. The arresting officer recommended a pat-down search because the woman had no criminal record, she was cooperative, and had only a small amount of marijuana at the time of the arrest and was to be handcuffed to a bench. The officer in charge disagreed and he ordered a strip search saying that drinking and driving indicate poor decision-making, which could lead to the woman's choosing to hand out marijuana to other detainees. The trial judge in that case found that the officer in charge had no reasonable grounds to order a strip search and highlighted the need for a distinction between searches that are appropriate when a detainee is integrated into a prison population and those circumstances where a suspect is held on a short-term basis in police cells. The judge found the decision to conduct a strip search was likely routine. Further, the concern of the officer in charge that the woman would pass along marijuana to other detainees was pure speculation, belied by the fact that she would be handcuffed to a bench. Evidence of breath readings was excluded and the charge was dismissed. In another case, in 2017 case, a judge threw out all drug evidence, finding police had no reasonable grounds to pull back a man's pants and boxer shorts at the scene of the arrest to locate concealed drugs. In her ruling in that case, the judge said, the officers were ignorant of the law. They thought that exigent circumstances justified when they did what they did, and that what they did was not a strip search. They were wrong, and this should not have happened. It does not mitigate the seriousness of the breach that the officers were ignorant of the law governing strip searches, and that they did not even understand that this was a strip search. Golden was not decided yesterday, it was decided in 2001. Judicial decisions and complaints to the OIPRD can highlight strip searches that were unlawful or otherwise improperly done. However, judicial decisions only represent cases that go before the courts. Complaints typically only represent cases where an interested complainant has continued with the complaints process through investigation to the completion of the case. These cannot accurately capture the scope of lawful and unlawful strip searches in Ontario. I determined that a proactive approach, a systemic review, was required to prevent unlawful or unreasonable strip searches from occurring. The Police Services Act gives me the authority to examine and review issues of a systemic nature that may give rise to public complaints, and to make recommendations to police chiefs, police services boards, the Attorney General, the Minister of Community Safety and Correctional Services, and any other body. In undertaking this review, my systemic team examined numerous judicial decisions and found unlawful strip searches had occurred. My report contains a section on these judicial decisions that provides data on the number and types of constitutional violations, the police services involved, and whether items were seized. These case summaries for these decisions are included in a supplemental report available on the OIPRD website. The information from these reported judicial cases involving findings of unconstitutional strip searches helped inform my report. In undertaking this review, I also requested policies, protocols, and procedures regarding strip searches from all Ontario municipal and provincial police services. I requested police statistics, data, and records on the use of strip searches, as well as information on training provided to police services, police officers on strip searches. I requested and received information from the Ontario Police College on officer training regarding strip searches. A number of police services and police associations made recommendations and suggestions regarding strip searches, policies, procedures, and practices. My examination of strip searches at the systemic level found that too many strip searches continue to be conducted, and too many strip searches continue to be the subject of adverse judicial findings. The examination revealed inconsistencies and inadequacies in existing police procedures. this is not even a common understanding across, there is not even a common understanding across the province on what constitutes a strip search and what does not. The examination revealed uneven treatment of arrested people, persons across the province, and inadequacies in training and knowledge of frontline officers and supervisors regarding strip searches. It also exposes significant deficiencies in how and what data and statistics are kept. Now I'm going to first address police procedures regarding strip searches. Then I will turn to training and strip searches, statistics and data collection. So let me talk about police service procedures. Every police service in Ontario has procedures that in some way cover strip searches. No service has standalone procedures specifically for strip searches. The procedures that police services submitted for this review were mostly based on the search of persons guidelines and prisoner care and control guideline that were created by the Ministry of Community Safety and Correctional Services. These guidelines are contained in the Police Services and Standards Manual. The Police and Standards Manual explains the standards Ontario's police must follow when implementing the Police Services Act. It provides guidelines on how services must follow the standards that are contained within it. These sample policies and guidelines are procedures for procedures advisory only. Police services boards and police chiefs are responsible for ensuring compliance. Many police services choose to use the language provided in the manual for procedures verbatim. While the Police and Standards Manual provides police services with basic guidance, it does not detail the responsibilities of police service members in conducting strip searches. Equally important, the manual was last updated in 2000, which is prior to the Golden Decision that took place in 2001. The fact that officers continue to misunderstand or fail to comply with their obligations in conducting, authorizing, or supervising strip searches makes clear the necessity for comprehensive and consistent procedures across Ontario. The Search of Persons Guideline and other guidelines that reference strip searches must be updated to reflect existing jurisprudence, including the decision of the Supreme Court of Canada in Regina versus Golden. My review revealed that police services across the province have adopted procedures that provide uneven and at times inconsistent directions to officers on what constitute a strip search and when and how this should be conducted, authorized, or supervise. Services should ensure that their strip search procedures are detailed enough to provide officers with clear direction for a variety of situations that may arise. For example, the definition of what constitutes a strip search in some police service procedures does not conform to the definition adopted by the Supreme Court of Canada in Golden. It should. There is no valid reason why a search recognized and treated as a strip search in Toronto should not be recognized and treated as a strip search in North Bay or in London or in Ottawa or anywhere else. In my report, I provide detailed analysis and comment on existing procedures and deficient police practices identified during my review, and I make recommendations for when a strip search can be conducted and how a strip search should be conducted. For example, my review found Toronto Police Service officers frequently relied solely on the fact that a detainee or an arrestee was being held for a show cause hearing as grounds for conducting a strip search. This occurred despite a September 2015 routine order from the Office of the Police Chief. It directed Toronto officers that Level 3 searches shall not be conducted on persons brought into custody by Toronto police officers based solely on the grounds that the person may come into contact with other persons in custody. Many, but not all, services have adopted procedures regarding searches of transgender persons. Only a few, though, have adopted procedures regarding the searches of persons wearing religious attire. In some jurisdictions, officers may not encounter these situations frequently, all the more reason why explicit direction is warranted and is necessary. In the Golden decision, the Supreme Court acknowledged that African Canadians and Aboriginal people are overrepresented in the criminal justice system and are therefore likely to represent a proportionate number of those who are arrested by police and are subject to personal searches, including strip searches. I have recommended that police services collect race data information. This is important. Police service procedures should specifically address how race-related information should be collected by frontline officers. My report includes a template for a procedure on strip searches that incorporates recommendations from various stakeholders as well as my own thoughts. It is intended to assist all officers, all Ontario Police Services, in creating or modifying their own strip search procedures. This template is designed to promote province-wide procedures that comply with existing jurisprudence and to promote best practices in circumstances not currently addressed in existing jurisprudence. The Policing Services Standards Manual requires police services to establish procedures for documenting searches of persons, introducing the circumstances when a strip search must be reported. Most police service procedures simply state that strip searches must be documented in officers' notes. In the information provided for this review, we saw numerous incidents where officers failed to properly articulate the grounds or document strip searches. In their submissions to my review, some police services observed that the problem rested, in part, on the failure to have consistent province-wide requirements for what must be documented. A number of these police services also recommended that this documentation should be done electronically to ensure searchability, monitoring, and accountability. I agree. My report contains a sample strip search form to enhance proper documentation of strip searches. I recommend that all police services adopt this form. I'll now refer to police training regarding strip searches. The most comprehensive and accurate procedures are ineffectual if officers do not adhere to them. Training is one means of promoting such adherence. The number of cases in which officers deviate from existing jurisprudence or procedures made it imperative for me to examine the training of police officers related to strip searches and searches more generally. Frontline officers and their supervisors make the decision about who gets searched and when and how the strip search occurs. Adequate training is crucial to prevent the inappropriate and unlawful exercise of police powers. I found many police services do not have an annual refresher training course specific to strip searches. Other police services include searches of persons training with the annual use of force training. In some of these services, there is no training at all regarding strip searches. The bottom line is that training regarding strip searches is uneven, both in relation to whether or when it is offered and in relation to its content. The court cases that turned on the lawfulness of a strip search raises serious issues about the training offered by police services, about their own procedures, as well as the extent to which such training has been effective. In my report, I recommend regular training for all Ontario police officers on searches of persons, including strip searches. This training should be informed by the most prevalent issues identified in judicial decisions as well as by the contents of this report. Talking about police service statistics on strip searches and data collection. The deficiencies in the collection of statistics and underlying documentation pertaining to strip searches prevented a full comparative analysis among police services across the province, or even a firm number of strip searches conducted in the province every year. However, the data provided did permit us to safely conclude that well over 22,000 strip searches took place in each of the years we examined in our research. The majority were conducted by the Toronto Police Service. Based on the totality of the evidence available, I have concluded that this represents a significant overuse of police strip search powers in Ontario. There is also an unaccepted disparity between whether and how various police services in Ontario carry out these strip searches. These and other issues, there are other issues with data collection. First, the majority of services were unable to provide me with all the information requested because while strip search information may be recorded in officers' notebooks, the information is not inputted into a computer system. Some police services have more recently moved towards electronic record keeping regarding prisoners, and as a result, were able to search for and provide data concerning the number of persons arrested and who were also strip searched. Second, some police services did not adequately or at all document in their notes or otherwise the type of searches conducted for suspects or accused upon detention or arrest. They did not record the grounds for the strip searches, or the number of times items were found as a result of a strip search, as opposed to another type of search, or they did not provide complete descriptions of the items found. Third, police service categorized searches differently. This meant that true strip searches were either unreported or at times inconsistently reported, meaning they were not reported in the same way across the province and across police services. It was obvious to us that some police services had an overly narrow view of what constituted a strip search. Let me try to explain. A strip search need not involve the complete removal of a subject's clothing. As long as it entails the removal or rearrangement of clothing to permit the visual inspection of the subject's private areas or undergarments. And I emphasize undergarments, because to view a suspect's undergarments constitute a strip search. Some police services think that only nudity defines a strip search. That is incorrect. This is an overly narrow view. Less police services were over-inclusive in what they characterize as strip searches. This means, for example, they included the search of hair, ears, mouth, and between fingers and toes as strip searches. These things skewed any true comparative analysis. Fourth, serious concerns exist about the role that race plays in whether and how a strip search is conducted. The inadequacy of existing data collected by police prevents police services boards, and oversight agencies from fully addressing these concerns. Historically, Ontario Police Services have not generally kept race-related statistics of the interactions with members of the public resulting in strip searches. This significantly impairs the ability of oversight agencies and others to conduct evidence-based rather than speculative evaluations of the role that race plays in whether and how strip searches are conducted. This type of evaluation is long overdue. I recommend that police keep and publish race-related statistics regarding strip searches in a manner consistent with the Ontario Human Rights Code and the expectations of Indigenous, Black, and other racialized communities. This echoes what the Ontario Human Rights Commissioner called for in a report on the public interest inquiry into racial profiling and racial discrimination of Black persons by the Toronto Police Service this past December. In my view, all police services in Ontario must keep accurate statistics of the number of persons they arrest or detain, the number of persons strip search, based on a common interpretation of what a strip search entails, and the justifications provided for such strip searches, including the necessary authorization. Statistics and full record keeping could also contribute to learning the extent to which strip searches result in the discovery of secreted items otherwise undiscoverable through less intrusive searches. This might inform best practices on a going forward basis. The collection of accurate statistics, uniform and comprehensive statistics on strip searches across Ontario will enable police services, the government, and oversight agencies to more easily compare existing practices, identify continuing concerns, and rectify them. In conclusion, folks, my report on strip searches set out the systemic issues identified across the province and makes recommendations for changes. They include recommendations to change existing policies, existing procedures and practices, training, and the collection of relevant data. I was pleased to see some police services treated this systemic review as a call to action. Some services began to reevaluate the existing procedures before my review was done. Toronto Police Service, whose officers conduct the most strip searches in this province, introduced new measures, including a full body scanner pilot project, an X-ray, which addresses some concerns identified in my review. I support this pilot project and would like to see it continue and expanded. These initiatives are a start, but they're only a start. There's still much more work to be done. My recommendations for consistent, comprehensive policies and procedures for strip searches, proper documentation, adequate statistics, and effective training can help to ensure strip searches are only done when needed and that they're done in accordance with the law. My recommendations, they provide a blueprint for best practices in policing. The spotlight my report shines on strip searches can help improve policing in this province, and in doing so, enhance the administration of justice and the lives of all members of our communities. Breaking the Golden Rule is the fourth systemic review that my office has completed, and it is my last review. My term as Independent Police Review Director ends on March 31st, 2019. However, I do not believe that systemic reviews will end with me. The proposed Comprehensive Ontario Police Services Act 2019 continues the power of the Director to conduct systemic reviews, and I hope he or she will do so. It also improves the impact of systemic reviews recommendations by requiring police services to notify the Director whether the recommendations have been accepted, and if not, the reasons why not. Systemic reviews are powerful tools for determining whether systemic failings have occurred, identify and document issues that needs to be addressed, and make recommendations that can assist in policing organization in correcting problems that exist within that organization. Systemic reviews can resolve a vast number of potential complaints before they even happen, and they can contribute to preserving public confidence and trust in civilian oversight, as well as trust in police and policing. I want to thank you for taking the time to listen to me today in regards to the release of this report. Thank you. I'm happy to answer some questions, and if there are some questions, I may ask my counsel to provide some responses to.
Thank you, Dr. McNeilly. I want to talk about the Toronto police statistics because, frankly, they're staggering. These findings suggest that out of 10 arrests, 4 people are going to be strip searched. Can you explain sort of
Okay, I'll ask Mark Sandler to respond to that.
Well, the simple but not so simple answer is that there are a variety of factors that we saw identified that explains the disparity. It's not simply explained by differences in statistical collection. In our view, it did represent a difference in practice as between the Toronto Police Service and some of the other police services. It also represented, in fairness to the Toronto Police, some differences in the extent to which officers knew whether individuals would be placed in a general prison population as opposed to in isolated cells. In some instances, the Toronto Police Service has less opportunity to isolate an individual as opposed to knowing that they're going into a general population, which raises other considerations. But we also identified that that did not explain, in whole or largely, the disparity. And frankly, one of the advantages of a systemic review is that we do engage in an ongoing dialogue with the service, the various services in the province during the currency of this review. So we had ongoing dialogue with the Toronto Police Service and other police services as our findings were developed. And I like to think it contributed to some introspection on the part of all services, including the Toronto Police Service, as to how they've got to do better here. And as the director indicated, they have introduced a pilot project. We indicated that we were supportive of the pilot project, and it's hoped that if the pilot project represents a viable alternative to conducting strip searches, then we'll see very sharp diminution in the numbers of strip searches that are being conducted by the Toronto Police Service.
What about in a situation where there are no grounds to articulate a level 3 search and a prisoner is being kept in custody and the officer in charge doesn't authorize the search, or let's say the arresting officer doesn't ask for a level 3 search. Person put into custody and he harms himself or herself, or even worse, kills themselves in custody when a level 3 search wasn't done because there was no justification for it. Is there a protection for the officers in that particular case?
So the answer is that when the Supreme Court of Canada decided the Golden Decision, they were very much alive, as we were, to the fact that strip searches may indeed be justified under circumstances to protect officer safety and indeed to protect the safety of the subject of the strip search. So as you'll see on a detailed review of our report, this isn't about doing away with a necessary tool to protect either officer safety or the safety of the individual involved. What it is that even recognizing those safety concerns, too many strip searches are nonetheless being done. And if the officer is reasonably of the view that his or her own safety or the safety of the person concerned is such that a strip search has to be done or a more intrusive level of interaction has to take place, then we have established processes where they can document what it is that has brought about that concern, why that concern has taken place, and how they accommodated that within a safety framework. So this isn't an indictment of strip searches. This is concerns expressed about whether or not the strip searches that are being performed go well beyond those that are necessary to address the issues that you've said. And the courts have said the same thing as well in the many cases that we documented where courts have found that officer safety or the safety of the person involved did not justify the strip search.
But in a situation where there is no real justification for a level 3 search and a person is being kept in custody and something were to happen, something were to happen to that prisoner because the officers felt that there was no justification for a level 3 search. He's kept in custody, goes for a show cause hearing. He or she has something followed up and it causes harm to himself or somebody else. Does that leave the police open to any sort of criticism on that part when they felt up front that there was no justification for the level 3 search?
If the police officers are in compliance with the existing law, as I would understand the existing jurisprudence, they'd be protected against liability on that basis.
Yeah. And I think as Mark indicated, as long as they articulate the reasons why and they follow the procedures and policies and act in accordance with the law, I think they'll be safe.
And that's articulated for or against
That's right.
I did it or I didn't do it.
That's right, yeah. As long as they're able to articulate, and the most important thing, as we have indicated in the report, and we provide the suggested document for completion, is that the problem is they have not been articulated or recorded why or why not. And what we're suggesting is that you do that, and if you do that, you've covered your bases.
Just gonna add something. Just important to add one point, and that is that a number of officers, whether by associations or through the service, who made representations to us, welcome a more comprehensive, thorough approach where they know what the ground rules are. And it's so much easier for police officers to comply with the ground rules and their obligations if they're known, if they're documented, and they're comprehensive across the province.
Mr. McNeilly, I have one more question. You cited a few cases where evidence was dismissed because of the unlawful search and seizure. Do you think that's more of a training issue, or is that a blatant disregard for Section 8 of the Charter? What's your feeling on why the police are losing so many of those cases in court with regards to the unlawful search?
I think it has a lot to do with training, and we emphasize that in the report. I mean, we've had officers who said that I've been an officer for 12 years and I didn't know Golden existed. And so it has a lot to do with training. It has a lot to do with the policies adopted by the services, not just with the rank and file officers, but superior officers, the officers in charge. And so it's really, in my opinion, a real big training issue. Is there some disregard at times? Surely, maybe. I don't know. But what we have seen is that it's a training issue at this time. Ms. Wendy.
22,000 strip searches, is that a safe estimate given the complete lack of data with many other police services?
Yes, based on the evidence we're able to collect, based on the data we're able to collect from police services, I think that's a safe estimate, yes.
At least 22,000.
At least, yes. Any other questions? If not, I'd like to thank you all and for coming today. And we always appreciate feedback. And I sincerely recommend to police services across this province, the police services boards, to the ministry, the Attorney General, and community and services that they look at these recommendations, these 50 recommendations carefully, and that they proceed to have them implemented. I think it will make a big difference in regards to the confidence and trust that the public will have in police and policing. And I think, as Mark has indicated, it would also help police officers understand clearly what their role and their purpose is in carrying out strip searches. Thank you.